Picture this. You're arrested. Police put you in an interrogation room. They read you your rights, and those famous words echo in your ears. You have the right to remain silent. But where did those rights come from? Why do police have to tell you this? The answer lies in a case that changed criminal justice forever. And it started with a man named Ernesto Miranda, a kidnapper and rapist facing the death penalty in Arizona. His case would eventually reach the highest court in the land and fundamentally alter how American law enforcement operates. But Miranda versus Arizona is just one chapter in a much larger story. Throughout American history, the Supreme Court has issued decisions that didn't just resolve legal disputes, they reshaped the nation itself. Some of these cases freed people from injustice, others sparked national controversy that still echoes today in 2026. Today we're going to walk through 5 of the most consequential Supreme Court decisions ever made, and we're going to show you exactly why they matter, not just historically, but right now. Let's start with the case that gave you your voice in the interrogation room. It's 1963 in Phoenix, Arizona, and a woman is kidnapped. The police have a suspect, Ernesto Miranda, a 23-year-old with a troubled past. They bring him in for questioning. No lawyer, no explanation of his rights, just hours of interrogation. And Miranda confesses, not because he knows he can refuse, but because he doesn't know he can. The confession is signed, sealed, and he's convicted of kidnapping and rape. Case closed. Or so everyone thought. But Miranda's court-appointed lawyer, John Flynn, saw something the Phoenix police didn't. He saw a violation. He saw a man who had no idea he had constitutional protections. He saw an opening. Flynn appealed the case all the way to the U.S. Supreme Court. On June 13, 1966, the Supreme Court issued its decision in Miranda versus Arizona. 5 justices to 4. The majority ruled that the police had violated Miranda's Fifth Amendment right against self-incrimination. The confession was inadmissible. Miranda got a new trial, and without the confession, the case fell apart. He was eventually released. But here's what makes this case revolutionary. The Supreme Court didn't just overturn his conviction. They created a rule, a mandate that would forever change how American police conduct interrogations. Before a suspect can be questioned in custody, police must inform them of 4 critical rights. The right to remain silent, that anything they say can be used against them in court, the right to an attorney, and that if they can't afford an attorney, one will be provided. These are the Miranda rights, and they exist because of one man's conviction that was secured through coercive interrogation. Fast forward to today in 2026, every police department in America operates under Miranda. You see it on television shows, you hear it in real police body camera footage. It's so woven into American criminal justice that it feels like it's always been there. But it hasn't. It's been 60 years since Miranda, and the landscape has shifted. In recent years, there's been significant debate about police procedures, about qualified immunity, use of force policies, and whether Miranda protections go far enough in an era of sophisticated interrogation techniques and digital surveillance. The Innocence Project has documented cases where false confessions were obtained even after Miranda warnings were given, often because suspects didn't fully understand their rights or were psychologically manipulated. This shows us that Miranda was a crucial step, but the fight for true protection in the interrogation room continues. Now let's travel back further in time to a case that goes to the very heart of American equality. It's 1954, and America is a nation divided. In the South, Jim Crow laws enforce rigid racial segregation. Schools are separate, restaurants are separate, water fountains are separate. The law of the land is that separate facilities can be equal, a doctrine established in 1896 in a case called Plessy versus Ferguson. But a group of lawyers, including the legendary Thurgood Marshall, believed that separate could never truly be equal. They decided to challenge the segregation of schools head-on. They brought cases from across the country, from Kansas, South Carolina, Virginia, Delaware, and Washington, D.C. But the lead case came from Topeka, Kansas, where a black girl named Linda Brown couldn't attend the all-white school just 5 blocks from her home. Instead, she had to ride a bus across town to an all-black school. Her father, Oliver Brown, sued. The case worked its way through the courts, and in 1954, it reached the Supreme Court. Thurgood Marshall argued passionately before the 9 justices. He presented psychological evidence showing that segregation itself harmed black children, damaging their self-esteem and sense of belonging. He argued that the Constitution does not permit the government to discriminate based on race, period. On May 17, 1954, Chief Justice Earl Warren delivered the decision. It was unanimous. 9 justices, 1 voice. Separate educational facilities are inherently unequal. Brown v. Board of Education didn't just overturn Plessy v. Ferguson. It struck at the legal foundation of Jim Crow. It said that segregation violates the Equal Protection Clause of the 14th Amendment. Schools had to desegregate. The following year, in Brown v. Son, the court ordered desegregation to proceed with all deliberate speed, language that in retrospect was far too lenient. Southern states resisted fiercely. There were massive protests. Governors mobilized the National Guard to block black students from entering white schools. It took federal troops and intense national struggle to enforce Brown. But the legal principle was crystal clear. The government cannot treat people differently based on race. This case became the foundation for the entire civil rights movement. It was cited in subsequent cases protecting voting rights, employment rights, housing rights. As we look at the legal landscape in 2026, Brown v. Board of Education remains the bedrock of civil rights law. And yet, the dream of truly integrated equal schools remains unfinished. Resegregation has occurred in many communities. The fight that Linda Brown's father started over 70 years ago is still being fought in courtrooms and school boards across America. Let's shift gears now to a case that might seem more obscure, but is absolutely fundamental to how American government works. It's 1803, and the nation is young, just 14 years old. Thomas Jefferson has just defeated John Adams in a bitter presidential election. Before leaving office, Adams appointed a man named William Marbury as a justice of the peace. But when Jefferson took office, his Secretary of State, a man named James Madison, refused to deliver Marbury's commission. Marbury sued, asking the Supreme Court to order Madison to give him the job. He filed his case directly with the Supreme Court under a law passed by Congress. But the Chief Justice, John Marshall, faced a problem. If he ruled in Marbury's favor, Madison likely wouldn't comply. The president wouldn't be forced to appoint someone he didn't want. But if he ruled against Marbury, it would look like the court was powerless. So Marshall did something brilliant. He ruled against Marbury. He said Marbury wasn't entitled to the commission. But in doing so, he established something far more important. He said that the law Congress had passed, which gave the Supreme Court the power to hear Marbury's case directly, was unconstitutional. In other words, the Supreme Court had the power to strike down laws passed by Congress if those laws violated the Constitution. This was revolutionary. Marbury v. Madison, decided on February 24, 1803, established the doctrine of judicial review. It said that the Supreme Court is the final arbiter of what the Constitution means. No law can stand if it violates the Constitution. This single case established the Supreme Court as a co-equal branch of government, not subordinate to Congress or the President. Without Marbury v. Madison, the Supreme Court would be a much weaker institution. Every major civil rights decision, every protection of individual liberty, they all rest on the foundation that Marbury established, that courts have the power to enforce the Constitution against everyone, including Congress and the President. Now we come to a case that divided America. In 1973, the Supreme Court issued a decision that was hailed by some as a triumph for women's rights and condemned by others as a moral catastrophe. Roe v. Wade established a constitutional right to abortion. Jane Roe, a pseudonym for a woman named Norma McCorvey, was pregnant and wanted to terminate her pregnancy. Texas law prohibited abortion except to save the mother's life. She challenged the law as unconstitutional. Justice Harry Blackmun wrote the majority opinion, establishing a trimester framework. In the first trimester, the state couldn't restrict abortion. In the second, the state could regulate abortion to protect maternal health. In the third trimester, the state could prohibit abortion, except when necessary to preserve the mother's life or health. For nearly 50 years, Roe v. Wade was the law of the land. Women had a constitutional right to abortion. But the legal and political battle never ended. The case remained controversial. Conservative justices and politicians worked relentlessly to overturn it. Then, in 2022, everything changed. The Supreme Court issued a new decision. Dobbs versus Jackson Women's Health Organization. The majority, now with 3 justices appointed by President Trump, overturned Roe v. Wade. They said there is no constitutional right to abortion. The decision returned the power to regulate abortion to the states. Some states immediately banned abortion almost entirely. Others protected it. The nation became a patchwork of different abortion laws. As we sit here in 2026, the Dobbs decision remains one of the most consequential Supreme Court rulings in modern history. It demonstrates something vital about the Supreme Court. Its power isn't just to interpret the Constitution, it's to reshape society. When Roe fell, abortion became illegal in multiple states overnight. Women's reproductive freedom, which had been protected as a constitutional right, suddenly became a matter of state law. This case shows us that Supreme Court decisions aren't abstract legal principles. They have real-world consequences for real people's lives. The fight over abortion continues to dominate American politics, and it all traces back to what the Supreme Court does and does not consider constitutional. Let's jump forward to 2015, a year that marked a historic moment for millions of Americans. On June 26, 2015, the Supreme Court issued a decision in Obergefell versus Hodges. James Obergefell had been in a same-sex relationship with John Arthur for 20 years. When Arthur was dying from ALS, the couple wanted to get married. But Ohio didn't allow same-sex marriage. They traveled to Maryland to marry, but when they returned to Ohio, the state refused to recognize their marriage. After Arthur died, Obergefell was listed as his unmarried partner on the death certificate instead of his spouse. He sued, challenging Ohio's ban on same-sex marriage and its refusal to recognize same-sex marriages from other states. The case reached the Supreme Court at a moment when the nation was deeply divided on marriage equality. Some states allowed same-sex marriage, others banned it. The Supreme Court had to answer a fundamental question. Does the Constitution protect the right of same-sex couples to marry? By a 5-4 vote, the court said yes. Justice Anthony Kennedy wrote the majority opinion, holding that the 14th Amendment's guarantee of equal protection and due process includes the right of same-sex couples to marry. Same-sex marriage became legal nationwide, in all 50 states, instantly. Obergefell versus Hodges is a perfect example of how the Supreme Court can transform society through constitutional interpretation. Overnight, millions of same-sex couples who had been denied the right to marry could now marry in every state. It was a monumental victory for marriage equality advocates, but it was also bitterly contested. The 4 dissenting justices argued that the court had overreached, that this was a decision that should be made by elected legislators, not judges. Today in 2026, same-sex marriage is fully legal and broadly accepted. Polls show overwhelming support among Americans of all ages. But Obergefell remains a flashpoint in debates about the proper role of the Supreme Court. Can the court mandate social change, or should it defer to the democratic process? So what do all these cases tell us about the Supreme Court and American law in 2026? First, they show that the Supreme Court is enormously powerful. A decision from 9 justices can reshape how police conduct interrogations across the entire country. It can desegregate schools. It can establish fundamental rights. It can overturn decades of precedent. Second, these cases show us that the Supreme Court's composition matters enormously. When justices change, the law can change. We saw this most dramatically with Dobbs, where the addition of new conservative justices led to the overturning of a 50-year-old precedent. Currently, in 2026, the court has a 6-3 conservative majority, which has already begun reshaping American law on voting rights, affirmative action, and other critical issues. Third, these cases remind us that Supreme Court decisions, while legally binding, don't always settle the underlying social and political questions. Brown v. Board of Education declared segregation unconstitutional, but schools remain segregated in many parts of America due to residential patterns and ongoing resistance to desegregation efforts. Roe v. Wade protected abortion rights for nearly 50 years, but political opponents never stopped fighting to overturn it, and they ultimately succeeded. Miranda established interrogation rights, but false confessions continue to occur. The Supreme Court can change the law, but changing hearts and minds is far harder. Fourth, these cases show that the Supreme Court evolves. The court that overturned Plessy versus Ferguson in 1954 was a very different institution from the court in 2026. Constitutional interpretation changes. New justices bring new perspectives. Public opinion shifts, the law follows. As we look ahead, there are several important cases on the 2026 Supreme Court docket that could reshape American law further. Issues of AI-generated evidence admissibility, voting rights, religious liberty, and government power continue to generate major constitutional litigation. Finally, and most importantly, these cases show us that the Supreme Court is not abstract. It is not just a bunch of judges sitting around debating legal philosophy. Every Supreme Court decision affects real human beings. Linda Brown couldn't walk to her neighborhood school. Ernesto Miranda spent years in prison for a crime where his confession was coerced. James Obergefell couldn't have his marriage recognized. Women across America lost their right to make decisions about their own bodies. These are not theoretical questions. They are about liberty, justice, and the fundamental rights that Americans hold dear. The Supreme Court matters. Its decisions matter, and as we move deeper into the 2020s, we should all pay attention to what the court does, because the cases it decides today will shape American society for decades to come. What do you think about these landmark cases? Which Supreme Court decision do you think has had the biggest impact on America? Leave your verdict in the comments below, and if you're fascinated by law, justice, and the stories behind the cases that changed everything, subscribe to The Verdict Room. We cover the cases that matter, the law that shapes us, and the real human stories behind the courts. Thanks for watching, and we'll see you in the next one.